We are so mature that 7 years ago, we had the nullification of the only presidential election.
Honorable Senators. Senator Fernandi, take your seat. Senator Kipsang, may the Council for the National Assembly be heard in silence.
Thank you, Mr. Speaker. 7 years ago, we had the nullification of the only presidential election known to history. And today, Mr. Speaker, we are conducting impeachment proceedings unknown to this continent outside of the removal proceedings in a parliamentary system in South Africa. Mr. Speaker, I want to thank you and the Senate for demonstrating the maturity of a democracy. So much so that even when the Deputy President is unable to appear without anything on record, this Honorable Senate has accorded the Deputy Speaker the opportunity, the Deputy President, the opportunity for his counsel to be present, and they have voluntarily exited. The right to appear in person or by counsel is a right under Article 145. But like every other right, you can choose to exercise it or not to exercise it. The idea and the fact of these impeachment proceedings being open as they are and being so democratic, even to vote on the procedural motion, shows how mature our country has become. Mr. Speaker, before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes. The fact that we are here in a situation where to impeach a Deputy President, we have to go through these processes, Mr. Speaker, it shows our maturity. But let it not be mistaken, Mr. Speaker, as some people have, that the process of impeachment is a criminal trial. When you hear people ask the mover of the motion, do you have any proof? Can you demonstrate? It means they are confusing this process with a criminal process. It is not a criminal process. Mr. Speaker, what we have in impeachment is a halfway house between the whim before 2010 and the beyond reasonable doubt proof in a criminal trial. In the words of Article 50, all you have to show is reason to believe. Reason to believe. What the lawyers would call just a prima facie case. You do not have to demonstrate beyond reasonable doubt. So all the questions that I had my learned friends putting to the mover to prove, to demonstrate, they look good to the public gallery, but they add no value to the test for impeachment. Mr. Speaker, impeachment is like a vote of confidence or a vote of no confidence. Just the same way when you vote the president and the deputy, no one asks you to justify why, because you exercise your discretion. When you lose that confidence, no one should ask you to demonstrate why. That is why it's a political process. Otherwise, it could have been a judicial process or a religious process. Mr. Speaker, it is important to make two distinctions. First, that in this process, you do not have to prove anything beyond reasonable doubt. That's number one. The beyond reasonable doubt can come later when the other processes come in, like the investigative agencies. Number two, Mr. Speaker, in courts, our courts use an adversarial system where you bring all the documents and you are restricted to what you have brought. The process in this house is inquisitorial under Article 145 all the way to 149. And therefore, it allows this house to go beyond what the mover has brought or beyond what the other witnesses have brought. And this house has exercised that jurisdiction quite maturely. Mr. Speaker, I want to suggest that the idea of impeachment is one which is legal in process only, legal in process, but political in content and merit. As long as all the legal processes for fair hearing are observed, it is not open to anyone to question the merit in terms of the decision of the National Assembly or the Senate, because the safeguard is in the numbers. That is why before you move it in the National Assembly, you need 117 members. For it to pass, you need at least 2/3. Even in this house, you need 2/3. That is the safeguard. The safeguard is not in the legal technicalities. Mr. Speaker, for that reason, while it looks juicy and it looks very good to the gallery to have that intense cross-examination such as we saw of the mover of the motion. Mr. Speaker, it is irrelevant. It is highly irrelevant, and to the untrained eye, they might think you are achieving much, but you are not achieving much. It must be remembered that the impeachment here is of the deputy president, not the mover of the motion. So however much you discredit the mover of the motion, you do your client no justice when you do not address the substance of what is moved. Mr. Speaker, allow me to refocus on Article 150. Article 150 makes a very important distinction. And I heard the lawyers of the deputy president saying that, there's precedent. There is no precedent in our court in terms of impeachment. There is precedent in terms of removal from office of governors under Article 181. The word used is removal. The word impeachment does not appear in Article 181. But when you come to Article 150, two words are used. You can remove the deputy president first, Mr. Speaker, under 151A, under 151 is removal. To that extent, the question of removal in 151, you can use the same standards in Article 181. But B, it says, or on impeachment. There is no other provision for impeachment, and we have not undertaken impeachment in this country. For that reason, Mr. Speaker, while the wording might look similar, the principles are different. Because for removal, for example, under 151, is a strict legal process. You have to show and demonstrate that the deputy president, has physical or mental incapacity. But when it comes to impeachment, it's a different matter. It's more of a political matter. Mr. Speaker, impeachment is a demonstration of impropriety, of unfitness for office, of it taking political responsibility. Indeed, Mr. Speaker, in a representative democracy, it is the way of unvoting someone you had voted. Otherwise, you would be having a fresh election to decide, should we now remove this person from office? It is too expensive. The fact, Mr. Speaker, that you have 82% in the National Assembly voting for impeachment, and 2/3 if it succeeds in this House, you translate it to the millions that it represents. In the National Assembly, 82% translate to about 42 million out of the 50 million Kenyans. That is a significant number. Mr. Speaker, if this House is equally to vote, you translate it to the equivalent number of people it's representing. It is not a heavy matter. If it was any less, it would have been a decision for a single judge. Mr. Speaker, allow me to address two things, then I sit, in terms of substance. One, you have 11 charges. 4 of those charges oscillate around one issue, and that is the utterances by the deputy president. And the charge is he made insightful and discriminatory utterances to the effect that only those who voted for the Kenya Kwanza are entitled to resources and positions in government in Kenya. That is the summary of that charge. That charge is contained in ground 1, ground 5, ground 6, and ground 10. I want to submit, Mr. Speaker, that if you find even only that one charge to have been satisfied, then I want to implore the senators to vote yes for all those 4 grounds together. Has it been satisfied? Mr. Speaker, those utterances are admitted by the deputy president in the documents before you. The meanings of those words in their variety is known to you and is known to Kenyans. The danger in words is something we know in this country way back in 2007. In our neighboring country, Rwanda, we know what words did. I heard the lawyers of the deputy president suggest that he did not take any action. Under the law, under Article 10, under Article 27, you do not have to take any action. Utterances are enough, because utterances can do the very damage that the Constitution intends not to be done. Mr. Speaker, what is his response to that charge? There are 2. The first one is he was exercising free speech. Mr. Speaker, that is the easiest to dismiss. I invite the senators to look at Article 33, 2D, Roman 2. It is express, and it says, freedom of expression cannot include advocacy for discrimination, and that's what he was doing. What's the second defense? That whatever he was saying is contained in the various coalition agreements under the Kenya Kwanza coalition that were filed and signed before election. Mr. Speaker, with tremendous respect, allow me to remind the Deputy President that this is the Republic of Kenya, not the Republic of Kenya Kwanza. Mr. Speaker, for that reason, you cannot elevate agreements under the Kenya Kwanza coalition above the legislation of this country, above the constitution of this country. Section 13 of the NCIC Act is very clear that those utterances are unlawful, in fact criminal. Article 10 and Article 27 of the Constitution are equally clear that you cannot make such utterances. So to come and say that I uttered them because they are contained in a coalition for one particular political coalition is in fact an admission. It is an admission of violation of the Constitution. And Mr. Speaker, if members wanted one clear admission of guilt, it is this one. It is not denied, the justification cannot stand, and indeed, Mr. Speaker, once one of the senators asked for the justification, and I had the lawyers refer to the Schedule 3 of the Political Parties Act. Mr. Speaker, I invite the senators to look at Schedule 3, Clause 3E. It is very specific. It talks of sharing positions in the coalition structure, not sharing positions in government. And to try and mislead this august House makes it an aggravation of a wrong. And I invite you, Mr. Speaker, to find that there was a breach of this. And I think the worst of all is we were able to play a clip of the Deputy President after showing what he had uttered, saying that he has no apology. He said he has no apology. The clip was played here. I invite you to look at the 798 pages that he has filed. There is nowhere where he has rendered an apology. So he leaves you in a position where he says, even if he was not impeached, he will continue doing that because in his view, it is justified by the Kenya Kwanza coalition. Mr. Speaker, I invite the honorable senators to find that this ground has been proved and to impeach the Deputy President on ground 1, ground 5, ground 6, and ground 10 for breach of the NCIC Act, Section 13, and breach of Article 10 and 27 of the Constitution. My last point, Mr. Speaker, allegations of corruption. Mr. Speaker, this House has had the various allegations of corruptions. You had the very direct evidence of Dr. Mulwa in terms of KEMSA. You had the very direct evidence of the Deputy CEO of ESCC. You had the various evidence in terms of Olive Garden, Vipingo, Outspan, and many others. But I will not go there. I will let you assess that, and my colleagues will address that. I want to address one fundamental thing. In your bundle, honorable senators, in volume 2A of the exhibits, you will find reference to a particular court decision. This is the decision on page 60 of 123. That is the decision in Asset Recovery Agencies versus Rigathi Gachagua. This decision was referred to, but I just want to take you directly to the finding on page 77. This was a case that the Asset Recovery Agency filed against the Deputy President. And this case was actually finalized 10 days before the last general election. What did the court find? The court found positively and declared that Rigathi Gachagua was found to have been having funds which were proceeds of crime and therefore liable for forfeiture to the state to the extent of 200 million. Mr. Speaker, it is important to note that in the 798 pages of the document filed by the Deputy President, there is not a single document that shows that this judgment has been set aside, has been compromised, or revoked. In an inquisitorial system, you do not need to restrict yourself. Where there's a judgment produced that shows that you have been found guilty of having proceeds of crime, the expectation would be that you'd produce a document negating it. The fact that no document has been produced, I invite you to invoke an adverse inference that either there's no such document, or if there is, it does not deal with that finding. Mr. Speaker, I want to submit that there's good reason why that document was not produced. Why would you produce all the agreements of Kenya Kwanza and produce all sorts of other things except one page of a document that is the most important document? As it is, you do not have any document that shows that this finding was negated. Mr. Speaker, I want to suggest that had it been produced, we would then have demonstrated that that document is unlawful. Because in law, and I submit respectfully, once you have been found guilty of what amounts to a criminal offense, you cannot then subsequently compromise it, because this is not a civil claim. A crime is a crime against the state. It is not personal to the Asset Recovery Agency. And therefore, those findings can only be set aside by positive findings of a superior court, and there's none. So the record shows that Rigathi Gachagua was convicted of corruption. And what that means, Mr. Speaker, that not only was he convicted, but even to come here and allege that he was convicted and thereafter, they entered some sort of negotiation, is in itself evidence of abuse of power. Because he was convicted 10 days before election, shortly thereafter, it is alleged they compromised it in what would be an illegality. Mr. Speaker, on that account, ground 7 of the charge must succeed. Respectfully, Mr. Speaker, honorable senators, I plead with you to find the Deputy President guilty of the grounds as charged. Thank you very much. Allow me now to introduce the Honorable George Murugara to take over.
Thank you very much, Mr. Speaker and honorable senators. My name is George Gitonga Murugara, Member of Parliament, National Assembly, and the Chairperson of Justice and Legal Affairs, and I'm here to represent the National Assembly with my colleagues. Honorable Speaker and senators, I'll deal with only one point which supports ground number 11 on the impeachment. And the ground 11 is insubordination and failure to actually act collectively with the other members of the cabinet and the presidency. There was an argument that was raised that some of the alleged misconduct on the part of the deputy president were actually committed when he was not the deputy president and therefore do not apply to the proceedings before this House. Reference is made to Article 151B of the Constitution, which provides that the ground for impeachment would only be serious consideration of serious reasons to believe that an offense has been committed. There is no time limit that is set, because once there are reasons to believe that an offense has been committed, then that stretches back to whatever time that offense would have been committed. This is to say, if in the pendency of the life of the presidency or the deputy president, it is discovered that before you assume the office, you committed an offense, that forms a ground for impeachment. This leads me to the next argument, which are the admissions that the deputy president actually made before the House. Clearly, he admitted that the issue of shareholding in Kenya was live, and he was part and parcel of it. Therefore, Kenyans were shareholders. He actually admitted in the House and also in the press in the country that he believed the president was behind this motion. He also admitted that he had actually gone against the principle of collective responsibility on the basis that the cabinet had made unconstitutional decisions, which decisions he had to disobey. He also went on to dismiss this parliament as a theater of the absurd, and that he did not expect much from here. The question is this, and that, honorable senators, you have to grapple with. If the deputy president was actually to be saved by this house, with whom would he work? He would not work with the Kenyans whom he has antagonized with his shareholding notion that he has spread across the country. Number two, he would have difficulty serving with his boss whom he has accused of being behind this motion. He would not actually work with the cabinet where he is responsible for everything that is done in the cabinet and the sub-cabinet committees brought together by the principle of collective responsibility. He would not be able to work with this parliament, which he has called a theater of the absurd. With whom would he work? This is the question you have to ask yourselves. What we have before us today is like a marriage, and I have to draw that analogy because actually the position occupied by the subject of that discussion and the motion, the Honorable Rigathi Gachagua, is now untenable. He cannot hold that position because his position is irretrievable. He cannot work with any of the organs and bodies he's supposed to work with. Therefore, the position being irretrievable, then it means actually he has to be impeached. And I implore upon you to actually do so. Where a marriage is irretrievably broken, you cannot apply any law. The marriage is gone. Whichever law you try to apply, it does not matter. For the deputy president today, we cannot apply any measure of legalese because this is not likely to assist us in any way. The position remains, this is a political process, these political offices they are holding, and therefore they are irretrievably broken. As I pen off, honorable senators, honorable speaker, sir, I'll refer you to a biblical book in the Old Testament, the book of Jonah, chapter 1. And when the senators retire, they can actually look at that, the entire chapter. What happened here when Jonah disobeyed the command from his superior, and that was the deity? He actually had to flee. And when he fled, he took a ship to a different city, not where he had been commanded to go. What remained was, on the journey, the waters were faced with tempest, and eventually the tempest had to be calmed by tossing Jonah out of the ship. The ship here is actually the presidency. The ocean is actually Kenya. Jonah is the insubordinate deputy president who actually cannot work with the entire government and the country, and whose position today, as he holds, is untenable. With those remarks, I urge you, honorable senators, to actually uphold this motion, and to the best of my belief and conviction, not only ground 11, which I have submitted, the rest of the grounds have been approved. Thank you very much. 2 minutes to Honorable Zamzam, who is also going to make a statement and a submission. Thank you very much.
Mheshimiwa Spika, kama mwakilishi wa bunge wa eneo bunge la Mombasa na bunge la taifa la Kenya, Mheshimiwa Spika, leo nimekuja hapa kuwaletea yale mashtaka ambayo yameonekana katika bunge letu. Mheshimiwa Spika, Mheshimiwa Spika, mengi yamezungumzwa. Mimi si mwanasheria, lakini mimi nazungumza kama yule Mkenya ambaye yuko pale chini, hajui sheria, hajui nini, anaomba amani katika taifa. Mheshimiwa Spika, Mheshimiwa Spika, video zimechezwa katika bunge hili. Tumeona Mheshimiwa Naibu wa Rais akijipiga kifua, hasa kule Taita Taveta. Nimeona Mheshimiwa Spika akiwaambia kuwa hawana shares, na akawaambia nyinyi kama mnataka hisa muongoje 2027, manake hata rais akinambia mimi niweze kuwaletea maendeleo, namwambia kwanza subiri niangalie kwenye mfuko wangu wakiwa kama wako kwenye orodha ya kupewa maendeleo. Mheshimiwa Spika, Mheshimiwa Spika, ifahamike kuna wakati mmoja Kenya iliingia kwenye vita sana. Mheshimiwa Spika, tuliona maiti ya kina mama, mtoto hajui mama amekufa, mtoto alikuwa ananyonya matiti. Mheshimiwa Spika, Mheshimiwa Spika, hatuwezi kutaka taifa hili lirudi kule tena. Mheshimiwa Spika, Mheshimiwa Spika, ndani ya Mombasa nina wajane ambao wananitegemea sana. Mheshimiwa Spika, uniletea malilio yao, na leo mimi kama mama kaunti wa Mombasa nalia kwa sababu ya mayatima ambao waliwachwa na ndugu ya naibu wa rais. Mheshimiwa Spika, haiwezekani kuwa leo mimi na mume wangu tutafute mali yetu na tuna watoto wetu, kisha akifa ende mbele ya Mwenyezi Mungu nije nipokonywe mali yangu niache na watoto wangu wakihangaika. Mheshimiwa Spika, ukiangalia umri ya hawa watoto wa ndugu yake Mheshimiwa naibu wa rais wametoshea kupewa urithi wao. Mheshimiwa Spika, lakini hata kuna tetesi mwingine yoozea kule kwa jela. Mheshimiwa Spika, kwa hiyo Mheshimiwa Spika, mimi nasema, nilisikia mwanasheria akisema to save makanga. Mimi nasema makanga ameiba pesa ya abiria, dereva hana pesa ya kupelekea mwenye gari. Kwa hiyo mimi nasema wamwache dereva apeleke abiria mpaka station ya mwisho, kisha akifika kule atajua atatafuta makanga mwingine namna gani. Mheshimiwa Spika, hatuna sisi uchungu na watu wa mlima, lakini tunachosema tulikuwa na Uhuru, tulikuwa na Kibaki, tulikuwa na Kenyatta, hatukuwahi kuona mambo ambayo tumeona kwa deputy president. Mheshimiwa Spika, huyu ni sumu, atavuruga Kenya, ataharibu Kenya. Naomba bunge hili la Seneti, amani ya Kenya iko kwenye mikono yenu, na waomba mtoe uamuzi wa uhakika. Huyu jamaa hapendezi kabisa kuwa katika nafasi ambayo yuko ndani sasa, na waomba kwa heshima na taadhima tuweze kumtimua leo, Kenya iweze kupata mtu ambaye atamsaidia rais kufanya kazi akiwa ameweka amani na umoja wa Kenya mbele. Asante sana Mheshimiwa Spika.
Mr. Speaker, sir, very briefly, I will wrap up the submissions on the part of the National Assembly. I'll endeavor not to repeat what has already been captured on the record. Mr. Speaker, sir, I've agonized and reflected on the place of impeachment proceedings, not just in our country, but across the world and across other democracies. Mr. Speaker, sir, I've had occasion to look at the history, particularly of the United States of America, from the days of Andrew Johnson in 1868, Richard Nixon in 1974, Bill Clinton 1998, and Donald Trump 2019. Mr. Speaker, sir, I asked myself, what does impeachment proceedings seek to serve in a democracy? In my reflections, one of the clear conclusions is that it is a check and a balance through which the populace can then hold their leaders accountable. It is an avenue through which the populace can ask their leaders whether they're doing that which is in keeping with the social contract or the understanding that they had at the point of election or delegating their direct powers to those elected leaders. So in the context of Kenya, where then do we find impeachment? Mr. Speaker, sir, our history has taught us very bitter lessons. We remember the events that bedeviled our country after the 2007 elections. It is after those events that we gave ourselves a new constitution. In that new constitution, Mr. Speaker, sir, we found it necessary to, in an unprecedented way, speak about our values, speak about the fabric of our society, the things that pull us together, the things that we share as a people. The preamble to our constitution, in particular paragraph 3, reads, "We, the people of Kenya, proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation," and continues so on and so forth. From those words, we realize what the thinking of the Kenyan people was right from page 1 of framing of our constitution. We then went to substantive provisions. A lot has been said about Article 10 of our constitution, to the extent that it speaks to the values that as a people we want to be associated with. We have dedicated a whole chapter of our constitution to the questions around leadership and integrity. It then tells us how central the values that we hold are to each other as a nation. Now, if we look at impeachment from that lens, then we realize and appreciate that impeachment then comes in to hold our leaders at an even higher pedestal, so that we have a tone at the top that is acceptable, a tone that gives us what has been called elsewhere political hygiene. We have had occasion in this country where people who have been in positions of leadership have been treated in what other people have thought has been harsh treatments. But it is because when there's a tone at the leadership to be set, it must be clear, it must be vibrant, and it must be the right tone. We've had leadership, people from the leadership who've lost their office because of having pinched somebody. We have people who have lost their offices because of utterances that were considered inappropriate. A slap has gotten somebody to go through a fairly painful process. It is because the slap is not necessarily the issue, it is the message that it sends. And so similarly, when we talk about our leaders, we then must ask ourselves, what does one wrong word do to the fabric of our society? It is on the basis of that background that we then consider the impeachment motion that is currently before this House. My colleagues who have spoken before me have taken us through the provisions of Article 150, 1B, which then speaks to the very grounds that this House should consider in whether to impeach His Excellency, the Deputy President, or not. I wouldn't want to go into those grounds because the record before this House contains material in support of those grounds. I would urge, Mr. Speaker, sir, that now that His Excellency, the Deputy President, has had occasion to present material before this House, that this House could consider in response to the motion for impeachment. When you retire to debate, to deliberate, we urge that you take into consideration the entirety of that material. We also ask that you also take time to look at what the mover of the motion presented before this House, as well as all the witnesses, including what came from public participation. That would give us an opportunity to, in a very objective way, reflect on what and how to deal with the questions that have been presented. I need not go into the specifics of each of the charges, but if I was to give examples, when we have a leader occupying the high office of the Deputy President of this country, somebody who is required by the Constitution to take an oath confirming or affirming to Kenyans that they will not divulge whatever comes out of secrecy confidential conversations that come to their knowledge by virtue of the office that they occupy, if that person then defies that bond or that commitment that they've had with Kenyans, it is a gross violation. Similarly, when we have somebody occupying the space of the high calling of the office of the deputy president, admitting issues that would amount to conflict of interest between his personal interest, his family interest, and which have financial implications. Again, our laws then dictate that those are reasons that would would be sufficient to impeach such a deputy president. We've had examples that have been given about utterances that have been considered to be unpalatable. Again, looking at the entire framework of what our Constitution anticipates, looking at what those words would mean to a man off the streets of Nairobi, off the streets of Mombasa, or any other place, if we all come to the understanding that those words taken in their natural meaning could cause some measure of discomfort, they are considered to be divisive, they are considered to be of such a nature as to bring or sow seeds of discord between us as people in this country, then it is the responsibility of this House to speak, and to speak on behalf of the people of Kenya, because it is one way of ensuring that there are checks and balances that flow from the constitutional powers vested in this House. Mr. Speaker, sir, as has been demonstrated through the many tons of documents that have been availed before this House, the cross-examination that has attended to the witnesses that have been before this House, and the material that has been placed by the mover, by all the parties who've had an opportunity to participate in the proceedings of this House, we have absolutely no doubt that this House is perfectly capable of making the appropriate decision in each and every of those counts. And just for emphasis, Article 150, Subarticle 1B, gives us 3 grounds. We do not have to have beyond 1. Any one of those is more than sufficient to make the call or to pull the trigger on an impeachment motion. Mr. Speaker, with that, I rest, and we thank you for according us this opportunity this evening. Most obliged.
So, are you done now with your submissions?
Yes, Mr. Speaker, sir.
Thank you.
We are done.
Thank you. Now, honorable senators, I'll refer you to the program. You will notice that after the closing statements from the parties, the Senate is supposed to move to a closed session to deliberate on the issues that have been raised. And that is pursuant to our rules of procedure. That is demanded of us by the rules of procedure. So at this juncture, I will allow the parties to retire as the Senate moves to a closed session. That closed session will take us not more than half an hour. After that, we'll come back. Once we are back, there's going to be a special motion contained in an order paper. That is the motion that will allow debate culminating into honorable senators getting the opportunity to cast their vote on each of those charges, of the 11 charges. So, Counsel for the National Assembly, you may now retire.